Welcome to the Law and Crime Network, everybody. I'm Aaron Keller, and welcome especially to those of you listening on Sirius XM satellite radio. We have a lot of cases to talk about today, including the Shaun Harrison case. It's basically an attempted murder case in the Boston, Massachusetts area. That case expected to go to closing arguments in about a half an hour. We are also talking about the Yesenia Sesmas case, where a woman is accused of killing another woman and taking that victim's baby and passing that baby off as her own. Jury selection continues in that case. We're keeping a close eye on that courtroom. But first, a verdict in the civil case of magician David Copperfield. He was found negligent late last night in a trial where a participant in a magic trick alleged that Copperfield, his company, and MGM Grand, which owned the property where that trick was being performed, was negligent and therefore responsible of injuries. Now, I said David Copperfield was found negligent along with his company and MGM, but is he on the hook for damages? The answer is no, because the jury found that none of them were actually liable and that the person who was playing a role in the trick was 100% at fault. Let's listen now to that verdict that was delivered late last night by a jury in Las Vegas. Well, we're going to talk about that a little bit. Sorry about that. So I want to bring in Dan Schorr, who is managing director at Kroll, along with being an attorney himself. Interesting verdict last night. David Copperfield, negligent, but the plaintiff 100% at fault. It doesn't make a lot of logical sense.
Right. The jury found that David Copperfield and the other defendants were negligent, and that means that they ignored some risk of harm that they should have appreciated and they should have done a better job, but they found that the actual liability was all on the plaintiff's side, that he was responsible for his own injuries through his own actions, and therefore David Copperfield doesn't have to pay any money out, nor do the other defendants.
Yeah. A strange verdict. Theoretically, it is possible, though, because keep in mind there are a couple different stages to a civil trial. It's different from what we normally watch here. There is a phase where the jury has to determine, is there negligence? In other words, did someone fall below a standard duty of care, resulting in the plaintiff's injuries? And then if they find yes, then in most states, in most negligence systems, they have to apportion out the percentages of fault. Was the plaintiff responsible for some of his or her own injuries? Or was the defendant responsible? Were a series of defendants responsible, and to what degree? Now, here, in theory, they could have said the plaintiff is 25% responsible, somebody else is, 50% responsible, and somebody else is 25% responsible, and then different state laws take it from there. Here, they just turned around and said, no, the plaintiff who was being led down these dark tunnels and there was construction debris around, that was the allegation. The jury basically said, yes, the condition existed, which caused this plaintiff who was being scurried through these tunnels to slip and fall. They said that the condition existed, in other words, that's what I'm reading into this, but plaintiff, it's your own fault that you slipped.
Right, either it's your own fault or there's an assumption of risk, or in some form, he either agreed to do this, it was an assumption of risk, or he was negligent in his own way, or maybe the defendant's negligence didn't rise to the level where there are damages that needed to be awarded. But in some, the plaintiff has to be disappointed. It was a long trial. The plaintiff had a lot of medical bills from this injury, and the defendant, David Copperfield, and the other defendants don't have to pay anything.
Exactly. Well, that's going to wrap up our discussion of the David Copperfield verdict, an interesting verdict in a case that we were watching here at Law and Crime. We'll switch gears now and talk about another trial. This is the case against Yesenia Sesmas. She's a mother who is accused of killing a woman and then taking that woman's baby, passing it off as her own after she, the defendant herself, had unfortunately had a miscarriage. Let's get up to date on that case, which is still in jury selection. And just to talk briefly about that case, Dan, here it's going to be a really tricky one, or a difficult one for the defense, because you have the defendant making a lot of admissions to the police. Okay, there are pictures of her with the child. What other reason would there be for her to have this child but for that she took it from the victim, whom she basically admitted discharging a gun around?
She totally admitted it. She admitted that she killed the victim. She admitted that she took the baby. it's hard to get around that. Now, she's going to say it was accidentally discharged, the weapon, but
yeah, there's hard to believe. She was vague about the way the gun went off. Oh, I had a gun, it just went off. Well, I mean, to quote the Tex McIver jury, guns don't just go off.
Also, she's kind of caught in that she has to say that because it's clear she shot the victim here. She took the baby, so she could say she maybe accidentally shot the victim, but still, that's not going to get her out from this charge. So it's really hard to see how she escapes. There's also another woman who says she was attacked by this defendant prior a few years ago, maybe in another attempt to kidnap her baby. So that might come in also into evidence here.
It might. We'll have to wait and see how far the judge stretches the rule allowing those other bad acts in, and it's a topic of frequent discussion here. So we also want to get you folks up to date on some of the other top crime stories that are making headlines. This is as we wait anxiously for closing arguments in the Shaun Harrison trial out of Boston. That got you up to date on the top stories, but we're also waiting anxiously, as I said, for the Shaun Harrison trial to resume in Boston, Massachusetts. This is the case where a school administrator who was also a preacher who had a message of anti-drugs, anti-guns, anti-gangs, is accused of shooting a student in the head. That student miraculously survived, got up on the witness stand and pointed the finger at the defendant and said, yes, he is the guy who shot me. That school administrator, the defendant, accused of living a double life. And let's start breaking this case down. Dan, no witnesses from the defense. Nothing. Not any character witnesses, not any alibi witnesses, nothing. What's the defense going to be? We're speculating a little bit here.
Right, I'm really interested to see the defense closing argument here. What is their argument going to be? The victim identifies the defendant as the one who shot him. He says that he went to the defendant's home and smoked marijuana and saw weapons. And this is a teacher, this is an administrator in his school. And in fact, when the police went to that home, there were weapons, there was marijuana. So that corroborates the student. And the defense, maybe they could say that this student has had problems in the past, that he had his own drug problems. But if you're going to be running a drug ring and shooting someone, as is alleged by the prosecution, of course, the people you associate with are going to have problems in their past. They're not going to be squeaky clean people. So I don't see what the defendant can say here. It'll be really interesting to watch.
I think you're right on the money there, and this is why. Look, we oftentimes look at these cases where there are drugs and at least perhaps undercurrents of gang activity. I'm speaking hypothetically here. And we're asked by prosecutors to take the word of people with colorable pasts on the witness stand. Well, here you have the corroborating evidence. You have the police going in and finding what the students said they would find. So it tends to lend credibility to the witnesses who are saying, yes, this is the guy who did it. But I'm wondering if what we're going to see here in about 20 minutes when these closing arguments begin is the defense saying, look, you can't believe these people. That might be the only place the defense has to go. One of the witnesses who was on the stand in this case, Cherie Strickland, was waved down by that victim, Luis Rodriguez, after he was shot and, as I said before, miraculously survived. She's the one who called 911. Let's listen to some of her testimony.
What were you doing that evening around 7 p.m.?
Me and Jeffrey Bullock were heading to Olive Garden, South Bay.
And you were going from where to the Olive Garden? Where were you? Just the general area?
Over Dorchester.
And at some point, did you drive down Magazine Street?
Yes.
What happened as you were driving down Magazine Street?
As we were driving down Magazine Street, someone walked into the street and flagged us down to pull over.
Who was driving the car that night?
Jeffrey Bullock.
What kind of car?
A Jeep Compass.
That person that walked into the street and flagged you down, can you describe what that person looked like?
It was a young teenager, Hispanic background.
Did you notice anything else about him?
He was bleeding from his ear.
How much blood are we talking about?
Lots of blood coming down onto his clothes.
Which way did he come? He stepped in front of you as you were driving down the road?
He stepped in front of our car to flag us down.
Okay. Did Mr. Bullock stop the car?
Yes.
When he stopped the car, what happened next?
That's when the person approached our car window on my passenger side, and I cracked it for him to talk to us.
Cracked it how far?
About 2 inches.
Why did you only crack it 2 inches?
I wanted to be able to hear him, but not for him to be able to do anything else because I didn't know who he was.
Have you been down Magazine Street before?
Yes.
What type of area is that generally?
Secluded, not really like a good neighborhood.
So how did this person who was bleeding who approached you make you feel at the time?
Very scared and nervous.
What happens next?
He tells me that he believes he just got shot and that he doesn't want to die.
Was there anybody else on scene, or was it just you
No.
and Jeffrey?
Just me and Jeffrey.
What happens next?
I called the police for somebody to come and rescue him.
911, this call is recorded. Operator 388. Honey, I'm down.
Ma'am, I'm just going to pause it right there for one moment. There was a 911 operator, is that right?
Yes.
And the second voice on there, is that your voice?
Yes.
Hello?
Hi, I'm on Magazine Street. Somebody just got shot. He's right here with me.
What number magazine on Cross Street?
What number? Where are we?
Hello, what? Give me a Cross Street, ma'am.
What cross street are we at? What are we next to? What building?
Magazine in Norfolk Street.
Magazine, Norfolk Street. He's bleeding a lot. Honey, I'm calling 911. Yep.
Okay, stay on the line with me, okay?
Yeah.
Let me get the call in.
Okay.
Okay, did anybody see anything?
Fuck. No, he's bleeding really bad.
Where was he shot?
He's shot in his face.
In his face?
Yes. He's bleeding really bad.
Did anybody see who did it?
No, just come. Please come.
The call already in, ma'am, but I need information.
Did anybody see you? Did anybody see you get shot? No.
Any cars, anybody? And
No,
nothing
no,
about-
we're the first person.
Okay, what's your first name, ma'am?
What was that?
Your first name, please.
Cherise.
All right, they're on their way.
Thank you so much.
You're welcome.
All right.
Nine.
After you made 911, the 911 call, how long did it take for police to arrive on scene?
5 minutes.
And were you having conversations with him at the time?
Yes.
Did you ever get out of the car?
No.
Who got out of the car?
Jeffrey Bullock.
Did he assist this young man?
Yes.
While you were in the car and Mr. Bullock was assisting him, what did you do?
Take a picture.
Take a picture of what?
I took a picture of the victim.
And I'm going to show you one photograph. Do you recognize that photograph?
Yes.
And what is that a photograph of?
Jeffrey Bullock checking on the victim as he bleeds from his ear.
And did you take that photograph?
Yes.
And is that a fair and accurate representation of what it looked like on March 3rd of 2015?
Yes.
Show you a second photograph. Do you recognize that photograph?
Yes.
What is that a photograph of?
The victim sitting down, bleeding from his ear, a better view of his face.
And the gentleman whose back is turned us on the right-hand side, who is
Jeffrey
that?
Bullock.
Is that a...
You are listening to the testimony of Sharice Strickland. She was the witness who found the victim, Luis Rodriguez, in the Shaun Harrison attempted murder trial out of Boston, Massachusetts. We just heard the 911 call. We heard the description of the scene. Dan Schorr, managing director at Kroll and attorney, is here with us to break this down. Dan, the big question coming up in a matter of moments, in closing argument, is what the defense is going to be. We know the defense didn't call any witnesses. I think we heard another nugget of the defense in reviewing that testimony, because there was no identification of the shooter immediately in the 911 call from the victim or from the caller. Is the defense going to turn around and say, look, it took a while for this victim to actually identify this particular defendant, and therefore it took him time to come up with a name which might not be accurate? It might be seen as spinning the truth, but is that going to be the defense?
They have to raise that. Certainly during cross-examination, they're implying that if this defendant really shot him, why wouldn't his name be mentioned? This testimony is powerful in terms of creating the scene and showing what happened and showing the extent of the injury, but it doesn't do much to actually prove the defendant guilty, because we know that the victim was shot here. There's no dispute about that. So it's a question of who did it. The victim ultimately tells the police that the defendant did it. Now, he doesn't take days or weeks to say that. When he's interviewed by the police, he says that this defendant shot him, but he didn't immediately say it to this driver and the people he was talking to originally. He may say, well, when he testified, he said, and you hear on the tape, he was afraid he was going to die. He says to the woman that
he's
he thinks
not
he's going
worried
to
about
die.
Identifying.
Yeah.
He's worried about medical care.
Now we have that whole dying declaration hearsay exception where people, as they think they're dying, can point to who did it, and that's an exception to the hearsay rule. And yes, he could have said, I was shot by this person, but at the time, he's shot in the head. He's bleeding on the street. He's desperately flagging down a driver, and he's afraid he's going to die. So he doesn't point out exactly who shot him. The defense will raise that. There's no doubt about that. But does it really prove some fabrication on his part? I think that's a stretch.
I will bet the defense will say, look, this guy had drugs, he had weapons, but that doesn't necessarily make him the killer, the attempted killer of this particular victim. That may be the defense, but we're getting ready for closing arguments here coming up in about 10 or 12 minutes in the Shaun Harrison trial in Boston, Massachusetts. The victim miraculously survived a gunshot wound to the head. We're going to continue to break it down as we wait for those closing arguments to begin here on the Law and Crime Network. Welcome back to the Law and Crime Network, and welcome again to those of you listening on Sirius XM Satellite Radio. I'm Aaron Keller. I'm here along with Dan Schorr, Managing Director at Kroll. He's also an attorney, and we're talking about the Shaun Harrison case out of Boston, Massachusetts. It basically boils down to an attempted murder case, along with a number of drugs and weapons charges against that defendant, who is a former school administrator who had a message that was anti-gang, anti-gun, anti-drug. He preached it everywhere, but authorities claim he was really living a double life and that he was indeed involved with all of the above. We've been listening to some of the critical testimony in this case from the passerby who was flagged down by the victim, Luis Rodriguez, after that victim, Mr. Rodriguez, was shot in the head. The victim said it was the defendant. That passerby was listening very closely to whether or not the defendant immediately made an identification of his attacker. He did not. That could give the defense a little bit of room to sort of attack the story that's been on the witness stand and that prosecutors are trying to prove. We're going to find out in a matter of about 10 minutes when closing arguments are set to pick up in this case. In the meantime, I want to take you back in time a little bit and look at some of the previous testimony in the Shaun Harrison case.
Pastor from Boston, who authorities claim lived a double life running a drug dealing ring, will resume this week. 58-year-old Reverend Shaun Harrison allegedly shot Luis Rodriguez in the back of the head in 2015.
Who shot you in the back of the head?
Mr. Shaun Harrison did.
Authorities reportedly have obtained surveillance camera footage that shows Harrison shooting Rodriguez. Luckily, Rodriguez, who was 17 years old at the time, survived the shooting. Harrison was mentoring Rodriguez before he recruited him to sell marijuana and allegedly shot him after a dispute. Upon searching his home, investigators found guns, ammunition, and large bags of marijuana. Rodriguez testified last week on the second day of trial, detailing how in a span of a month, he went from being mentored by Harrison to selling weed for him to being shot by him execution style. Prosecutors alleged Harrison shot Rodriguez due to his slumping drug sales. On cross-examination, defense attorney Bruce Carroll pressed Rodriguez on his prior history with drug sales and why he didn't immediately identify Harrison as the shooter. Harrison faces several counts, including armed assault to murder and illegal possession of drugs, firearms, and ammunition. I'm Anthony Velez for Law and Crime.
And to help us break down the Shaun Harrison case, which is expected to pick up with closing arguments in a matter of minutes, let's turn back to Dan Schorr. He's managing director at Kroll and an attorney. Dan, look, we're trying to figure out what the defense is. Let's talk a little bit about the prosecution. You have a victim who survived perhaps the scariest of all gunshot wounds. Right to the head, he gets up on the stand, extends his arm, points the finger at the defendant and says, yes, Mr. Harrison, my school administrator, is the guy who sucked me up into this world of drug dealing, and he is the one who shot me in the head. I don't think that it gets much better for a prosecutor than that.
Right, and if you're looking at it from the defense side, what is the motive for this victim to lie or to be incorrect about his identification? We see cases a lot, unfortunately, where people identify the wrong person, but usually it's because of either the lighting is bad or someone else looks like that person. But this is not that case. This is someone he's familiar with, he knows, he was spending time with. He said that the teacher recruited him, this administrator recruited him to sell drugs and showed him weapons. And in fact, when a search warrant was issued at the defendant's home, there was marijuana, there were weapons, there was some gang indications. So this is all consistent with what the victim is saying. He's saying he was shot in the head. It's hard to imagine what his motivation would be to lie and say it was this administrator when it was really somebody else.
Exactly. You have the corroboration, you have the victim, you have other witnesses on the stand. Look, this is a lengthy list of charges, 10 charges. The top charge in Massachusetts is armed assault with intent to murder. It's basically an attempted murder charge is what it boils down to. You have these other aggravated assault, battery, unlawful possession of a firearm, unlawful possession of ammunition. You have drug charges thrown in there, 10 charges in all. This is a really hard rap to try to beat without putting on any defense witnesses.
And the suggestion from the prosecution, although they can't say this explicitly, because the defendant, first of all, the defendant has no burden of proof. The defendant doesn't have to put forward any weapons. But nevertheless, if I'm a prosecutor in this case, I'm thinking they're not putting on the case because they have no evidence to offer. That if the defendant had a story to tell, he might tell it. Now, legally, he doesn't have to offer a story. He has the right to remain silent. He could just argue there's a reasonable doubt. But one would think if he had an alibi, he would offer it. If there was another explanation for where he was or who else might have done it, they would try to offer that. The fact that they called no witnesses and the prosecution case is so powerful says to me that the defense really doesn't have much to go on here.
That's what it suggests to me as well. Of course, the jurors are probably going to pay attention to that when they start hearing the closing arguments, which are set to begin about 5 minutes from now here on the Law and Crime Network. We'll take you to court live as soon as we can, as soon as those arguments begin. But I want to turn back to some of the cross-examination of the victim himself on the witness stand. That was his picture, Luis Rodriguez. He's the student, the former student of the defendants, who says that the defendant, his school administrator, shot him in the head. That was the voice of Luis Rodriguez, a victim in Boston, Massachusetts, who says that his school administrator, Shaun Harrison, is the one who shot him in the head. He survived that shooting, got up on the witness stand, and as you just heard, he was cross-examined about his use of marijuana. Dan Schorr is an attorney and managing director at Kroll. He's here with us. Dan, you don't really like the way that cross-examination went because it gave the prosecution the upper hand, basically.
Right. The defense attorney has to raise the issue of him being high during the time of these events that he's reporting, and then at closing arguments can say, look, he told you he was high when this happened, so he might not be able to perceive things accurately. Or he can call a witness about, an expert witness to say that when you're high, you can't perceive things accurately. But to actually say to this witness, when you're high, does it affect your perception? And he says no. Of course he's going to deny that. So he's really giving this to the witness to knock down the defendant's case. And you don't want to do that in cross-examination. You just want to lock down the facts as you see them, that you want to assert that are not in dispute. You were high, right? Okay. And when you went to the police, you didn't tell them initially who shot you, right? Now, those are all good points, but you don't want to give the witness the chance to wiggle around to say, yeah, I was high, but I still perceive things accurately and explain it the way he wants to, and that's what happened here.
Exactly. You have to be really closed-ended on cross-examination, and we talk about this frequently. You need to ask those pointed, biting questions to tear apart, to attack, sometimes not necessarily piranha-like, but politely attack the facts being offered by the witness in support of the prosecution's case, if you're a defense attorney. And here I agree with you, Dan. I don't think that happened. Let's listen to more of the cross-examination of Luis Rodriguez. Again, closing arguments in the Shaun Harrison attempted murder case in Boston, set to begin any moment now. As soon as they begin, we'll take you to that courtroom live. Welcome back to Law and Crime, everyone. I'm Aaron Keller. Welcome again to those of you listening on Sirius XM Satellite Radio. We're going to break down the Shaun Harrison attempted murder case out of Boston. He's facing a litany of other charges related to weapons, ammunition, and drugs. He basically admitted to some of the gun and some of the ammunition charges. But said, look, that's the only thing that I'm guilty of, is basically possessing this without the proper permits in that state. Prosecutors say he did a lot more than that, though. Let's break it all down. Dan Schorr remains with me here in studio. He's managing director at Kroll. He's also an attorney. And we also have Stacey Honowitz. She's a sex crimes prosecutor out of Fort Lauderdale, Florida. Good to see you both here on Law&Crime.
Hi, great to be here.
Okay, let's break this all down. Really severely competing closing arguments about the only thing that these two sides agree on is that the Reverend, who was working as a school administrator, Shaun Harrison, now a defendant, possessed these weapons and ammunition. Is that enough, Stacey, for the jurors to say, okay, we'll convict him of those three things. We think that the witnesses are shady. We don't think there's enough evidence to get him on the top charge, which is basically the Massachusetts analogy to attempted murder.
Well, listen, you never know what a jury's going to do. You know, I'm doing this for 30 years, and sometimes when you think that they're going to confess to a couple of counts, you're sure that obviously they're not going to convict on the main charge. In this case, you have the prosecutor who pretty much laid out all the overwhelming evidence that it couldn't be anybody else. I mean, the ammunition's found in the house. Their surveillance tape has the two of them together. He basically told this jury, you have the who, you have the what, you have the person. All of these things could not be coincidental. And I think his analogy to the magic trick in David Copperfield, he's basically, you know, in a sarcastic kind of tone saying, who else could it possibly be? So I think that them trying to admit to a couple of the counts makes them think that maybe, just maybe, we'll let him say that he had these things, but he didn't do the main charge. But I think the state was overwhelming in its presentation and its evidence that this is the person that also attempted to kill this individual, never thinking that this person was going to survive and be able to finger him in the courtroom.
Yeah, I mean, that was a powerful point. Dan, we talked about a couple of things earlier, and I want to inject them into this conversation. Look, the defendant doesn't have to prove anything. That's the state's burden. But a big question on a lot of people's minds is, okay, if the defendant wasn't involved in this, where was he? Where could he have been? We don't know the answer to that.
Yeah, there was no alibi. There's no records that he was in another place, that someone was with him. Now, he doesn't have to give any evidence. He can just argue there's a failure to prove the case beyond a reasonable doubt. So let's not put the burden on him. But then again, if we're trying to really evaluate what happened here, you would expect some story about where he was during that time if he wasn't there. And I think one of the big things that I keep going back to is the victim here. What's his motive to either be incorrect or to lie about who shot him? He knew this person. He knew the defendant really well. The defendant had gotten him allegedly to sell drugs. And in fact, there were drugs in his apartment. The defendant knew him for a while, so he's not mistaken that, oh, it looked like him, but it was really somebody else. So the only explanation is he made it up. Why would he lie? Why? He was shot in the head. He didn't fake being shot in the head. So why would he then make up someone else? The defense really never gave a plausible explanation for that.
Maybe to protect his buddies. Let's go back and take a listen to the defense's closing arguments that happened earlier today. We are breaking down the Shaun Harrison attempted murder trial out of Boston, Massachusetts, here on the Law&Crime Network. And welcome again to those of you listening on Sirius XM Satellite Radio. We have Stacey Honowitz on the line from Fort Lauderdale, Florida. Dan Schorr is managing director at Kroll and an attorney. Stacey is a sex crimes prosecutor. I want to throw a couple of questions on the table from these defense closing arguments. The first one, does it really work, Stacey, when a defendant who's opposing you in court cops to 3 charges and then says to the jury, we didn't do the rest of the charges? In this case, it would be 7 additional charges. Does that tactic work? We've seen it a lot lately. Or does it try to invade the decision-making province of the jury?
Well, listen, I mean, when there's overwhelming evidence that every count has been proven beyond and to the exclusion of every reasonable doubt, I think the defense feels like they have no choice, especially when ammunition and weapons and all of this evidence is found in the possession of the defendant. There's really nothing else to say. So does it work? I guess for some jurors, they might think, well, he wouldn't be confessing to this if it didn't happen, and he wouldn't be pleading not guilty if it didn't happen to this count. So it's a very hard tactic, but I think when the defense is up against the wall, when the evidence is there, when there's really nothing else to discuss, and as your other guest mentioned, that they didn't even say where the defendant was at the time, which is the biggest hurdle to get over, I think that they really don't have a choice. And they copped to 3, hoping that one juror on that panel is going to say, well, he would have copped to the first one, too, if he had done it. So you just never know.
Of course, we do wonder if we're going to wind up with a hung jury in many cases like this. But look, Dan, the defense here, at least in the beginning of the closing argument, is making this all about a question of possession. You know, look, there was this storage bin in the basement. They're making the case that this was sort of a common area in the basement that a lot of people could have had access to in this building where the defendant had an apartment. And look, you know the rules with criminal cases. When police find something in a common area, there's all this finger pointing. Everybody's trying to say the other person really possesses it. It's the roommate. It's my neighbor who has to store something down there. It's anybody else other than me. It's another tenant. That's what the defense is really pointing the finger at here. But look, the prosecution said during its argument on closing that there were items in the defendant's apartment. So is this nothing but a red herring here?
I don't think in the end it's going to mean much because he is, as we talked about, there's 3 charges of possession that he's admitting to. So right off the bat, he's going to be guilty of those. And then we have the attempted murder charge, which there's really strong evidence against him. Whether he's convicted or not is the main issue here. Those other possession issues, yeah, you could argue about those, and maybe he'll get off on 1 or 2 of those, but ultimately it's going to come down to, is he convicted of attempted murder? And then you already have him on these possession charges. So I don't think in terms of the ultimate sentencing, these other lesser counts are really going to matter.
It's all about the attempted murder charge, or the Massachusetts analogy to that charge. Again, folks, we're talking about the Shaun Harrison case out of the Boston, Massachusetts area, the case where prosecutors allege that a school administrator and preacher was living a double life as a drug dealer. He's accused of shooting a student in the back of the head, leaving him for dead. That student miraculously survived, got up on the stand and said, "It was my teacher, my administrator, who recruited me to sell drugs and then later shot me." Let's continue listening to the defense closing argument. We are talking, folks, about the Shaun Harrison attempted murder trial in Boston, Massachusetts. You were just listening to closing arguments from the defense from earlier today. The jury is in the process of getting the case right now. We continue to break down the arguments. Dan Schorr is managing director at Kroll. He is an attorney as well. Dan, look, I'll admit that there's a credibility issue here because the victim who was on the stand here didn't point the finger at the defendant, at least initially. There's a couple different versions of his story floating around there. Is that enough for the jury to look at this case and say, look, the story's inconsistent, the story about this particular defendant came into things rather late, therefore we can't believe it?
It's certainly the strongest argument the defense has, so they're going to push that as much as possible, as you saw the defense attorney do that. I don't think it ultimately will win the day for the defense because there's overwhelming evidence that this defendant had weapons, had drugs, was working with this victim, and the victim says that he shot him. There's no reason that's in evidence for why he would make that up and lie, and there's no other suspect that's being offered as another possible shooter. So it seems really hard for the defense to be acquitted on that count, but certainly they've done everything they can with the evidence available.
This is an argument where a lot of facts are thrown in, and some of the facts get a little bit fishy. Exactly where was all the evidence? Was it in the basement in a common area? Well, was it in the apartment? The jury's really going to have to try to remember all of that. So we're going to continue to break that down, but I know you need to hit the road, so great to see you again, Dan. We'll catch you the next time.
It's always great talking with you.
Okay,
Thanks.
well, I'm glad that you like to come back. So
absolutely,
we'll have you again. We're going to take a quick break, but when we come back here on Law and Crime, we are going to be continuing to break down the Shaun Harrison case. The jury is in the midst of getting the case. We will be in verdict watch soon. That's here on the Law and Crime Network. We'll join you again in just a few moments.